Hello and welcome to the Foodwell Alliance and the Law Farm's presentation of the Farm Law webinar series. This is the webinar from July of 2022, and it's about growing hemp in Georgia. And I want to give a big thank you first and foremost to Foodwell Alliance. They are the funders that make this free webinar series possible. Their support of the Law Farm provides these webinars, workshops that I'll tell you a little bit more about, and free office hours to farmers and growers in Foodwell Alliance's 5-county area. And I always forget them offhand, but I'll get to that too more specifically. So welcome, welcome. We're going to talk about growing hemp in Georgia. Georgia has had a hemp growing program. They've started making the laws and putting them in place as of 2019. And things are getting going, but still a very new program. And there are lots of misconceptions that I hear in the community. I had a lot of misconceptions as the laws were being finalized as well. So we're going to clear that up today. And thank you, Foodwell Alliance, for supporting this work in this time that we have together. I'm Michelle Namer. I'm an attorney and I'm the founder of the Law Farm. So we're talking about hemp tonight. But there are so many more legal topics that sustainable farmers have to deal with. My farm entrepreneurs that I work with deal with regularly. So if you're not already plugged in on Instagram at the.law.farm, I highly recommend following. And that's where I'll put some more resources. That's where I put updates on the webinars. Mark your calendars, October 27th. In the evening, there's going to be a what's missing in your most important contract workshop. And I put that in all caps because it's not just a webinar where I'm talking at you like this. It is going to be a hands-on, roll up the sleeves. I say get dirty, but a lot of y'all are growers. So you're not getting as dirty as you usually get. It's the legal version of getting dirty and getting into the contract that means the most to your bottom line. And looking at every single clause in there and figuring out what you can put in to better protect your assets, to CYA, cover your assets. Then November 14th, during the daytime, so you might still be in the office or near where your records are, we're going to have a record keeping workshop where we're just going to come together and think through, one, all the records that you may need from a legal perspective. We'll also going into some accounting things as well. And then quick and dirty tips for doing it. How is everyone else doing it? What are the apps? What are the resources you can use to up your record keeping game? And then there's going to be an employment law webinar toward the end of the year. The date is still to be decided. I am looking for an accountant who works with farm entrepreneurs as well, or at least in the farming industry. I cannot find that accountant who works with the farmers like I do. I'm looking. So if you have an accountant that you know and trust in the state of Georgia who works with sustainable, super small scale farms, please leave their information in the comments. If you're here tonight, leave their information in the chat and get me connected with them to get that employment law webinar put together for you with some tips on payroll as well. So yeah, follow me on Instagram or michelle@thelawfarm.com is how you can always email me any questions, comments, concerns. And I'm an attorney, so of course I come with a disclaimer. This presentation will not provide legal advice. This presentation will provide you with legal information and education. It will guide you and we'll guide together to transform dense law into clear action steps. And this is meant to empower you to integrate legal tools into your farm business infrastructure or food business infrastructure. There is no attorney-client relationship created in this webinar, and there is no confidentiality preserved with what you share in this webinar. So if you have a real-time dispute going on, please keep your questions very high level, hypothetical. Don't give anything away that you may have litigation pending or possibly pending on in the future. Just there is no confidentiality. This is going on YouTube eventually and thelawfarm.com. And if you have more questions, sign up for the office hours. They're at calendly.com /the law farm /office hours. And if your farm operations are in Clayton, Cobb, DeKalb, Fulton, or Gwinnett counties, these office hours are completely free. If you are outside of these counties, I'm offering the office hours at a huge discount of $75 for that hour with me. It's usually $250 to sign up for a working consultation. So if you're here tonight, if you're watching this webinar, you have follow-up questions, please use this access to me. If you're in Clayton, Cobb, DeKalb, Fulton, or Gwinnett, you can sign up for these office hours completely free. If you're outside of those counties, it is just $75 to meet with me for an hour to strategize, to ask questions and get things clarified. And Calendly is just a very user-friendly scheduling website. So when you go to that exact site, it will pull up a calendar that has all of my availability. It's already set up and you can just pick a date that works for you and you'll instantly be on my calendar. Answer a few questions and you'll instantly be on my calendar. So use that, use the office hours. I'm here. Again, that's something that Food Well Alliance generously funds to have as a resource available to the sustainable agriculture community. Use it, use it, use it. All right, and what we're going to cover in this webinar is Georgia's definition of hemp versus marijuana. We're going to talk about the licensing requirements to grow hemp in Georgia. And we're going to talk about the legal implications for growing hot hemp. And we'll talk about what hot hemp is. That's hemp that has become marijuana inadvertently. And so this is what we're talking about tonight. If you have other hemp questions, hemp growing questions, licensing questions, processing questions, again, reach out to me. I'm here for you. I'm a resource. But tonight we're going to talk about the definition of hemp versus marijuana, the licensing requirements in Georgia, and then the legal implications for growing hot hemp. So cannabis, marijuana, hemp, these words have been used in many conversations in many contexts, and maybe in not the exact specific legal way that they are meant to be used today as things are opening up, as more things are becoming decriminalized, legalized. It's important to know the distinction between cannabis, what is marijuana, what is hemp. Well, they're all the same plant. They're all cannabis. So I'm seeing now that I could have structured this with putting cannabis at the top. It's all cannabis. The cannabis plant either becomes marijuana or becomes hemp. And right now I say becomes because the difference is in legal definitions of THC concentration or CBD concentration, but let me keep it simple, the THC concentrations. So the difference between marijuana and hemp is in the legal definitions. Hemp in Georgia is the specific plant Cannabis sativa L with the federally defined THC level for hemp or a lower level. So Georgia references what the feds have defined as hemp. And it says in Georgia, if you have the Cannabis sativa L plant and the THC level is lower than what's defined federally for hemp, then it's hemp in Georgia. And the federally defined THC level for hemp is delta 9 THC concentration of not more than 0.3% on a dry weight basis, or the concentration for hemp defined in 7 USC section 5940, whichever is greater. And the 7 USC section 5940, that's federal code, that's the United States code. And so they're giving themselves a little bit of wiggle room to change that. So if it changes in that code chapter, then it changes here and it changes Georgia's definition. They all kind of reference one another and tie together. The takeaway from this slide is that in Georgia, if you're interested in becoming a licensee and a grower of hemp, you will be growing the Cannabis sativa L plant of many different varieties that all have a THC delta 9 concentration of not more than 0.3% on a dry weight basis. That's your take home. That's your take home. It's a big mouthful of a take home, but that's your take home of the difference between cannabis, marijuana, and hemp in Georgia. So let's have a quick science lesson to break down what that even means. So cannabis sativa, the plant, contains multiple chemical compounds unique to the plant. They're all, like any unique to cannabis compounds, are referred to as cannabinoids. THC and CBD are the most common. These are the ones that we're hearing about more and more as the legalization of hemp is happening, as the legalization of marijuana is happening in other places. The THC and the CBD is coming up pretty often. Oh, I meant to provide for context with the THC levels of marijuana versus hemp. That 0.3% that makes it legally hemp in Georgia. For comparison, I did a little Googling, and marijuana that you might have gotten in the 70s or 80s had like between 8% and 10% THC. I'm not sure if they meant on a dry weight basis or if it was exact, but I think it's interesting to compare that 0.3% versus what you could have found in the 70s, 80s, maybe even the 90s, that was around 10% tops. And now in these states where marijuana is legal, the marijuana that is sold can have into the 20%, 23%, 24% THC in the marijuana that is available. Just for context of what's what and the who's who of marijuana and hemp. So THC is tetrahydrocannabinol. Always gets me every time. Or the tetrahydrocannabinolic acid, or a combination of the two, according to the Georgia statute. So they're interested in any of the variations of the tetrahydrocannabinol. CBD is the cannabidiol. And CBD, you may have seen all over Georgia, is now readily available. You can get CBD dog chews, you can get CBD ointments, face creams, all the things, edibles, things for your skin. Yes, CBD, you have probably seen it in the state of Georgia. If you haven't yet, keep your eyes open. It is available because that is what is present in higher concentrations in the hemp plant and in the hemp products. And then we get to Delta 8 versus Delta 9. You may have also noticed that in the state of Georgia, the sale of Delta 8 THC products is happening. And it's a loophole. Delta 9 THC it's almost like a progression. It becomes Delta. The cannabinoids decarboxylize. They just lose a bond between hydrogens and they get it, or between carbons, and they get another hydrogen, or they get another oxygen hydrogen family member. And as they progress, and I think it starts as the tetrahydrocannabinolic acid, and then it's decarboxylized. Somebody may be able to correct me on that one. But it becomes Delta 8, then it becomes Delta 9 THC. And Delta 9 THC is the compound that is most, I'm going to say most for this comparison, for this conversation, gives it the most psychoactive effects. It actually binds to receptors that in our brain that produce the high, that produce the feeling of euphoria. That's the Delta 9 THC. Well, clever scientists have found that you can synthesize Delta 8 THC from the CBD that is in very high amounts in places where hemp is legal, and you can make products out of that Delta 8 THC, and it's only one carbon chain different than the Delta 9 THC. And so now folks are anecdotally testing that out to see if it's the same as Delta 9, and there are also formal scholarly articles being done to see the difference. So that's the difference between the Delta 8 and the Delta 9 that you may have seen, and that's THC and CBD. I feel like I am not doing my job if I do not loudly and clearly state that marijuana is still illegal federally and in Georgia. There has been some decriminalization. I know in the city of Clarkston, and I believe the city of Atlanta, and maybe some other metro cities have decriminalized marijuana, but it is still not legal. Decriminalization does not mean it's legal. It means you will not have a criminal charge, but you may still have to face a fine. You may still have to go to court if you're caught with possession of marijuana, or if you're caught growing it, any of those things. Decriminalization does not mean it is legal. There is legal medicinal marijuana oil in Georgia, or Georgia made medicinal marijuana oil legal. And for years after it made it legal, there was this weird, it's legal now for certain patients with certain ailments, but you're not allowed to sell it or grow it in Georgia or have it in Georgia. So the people who were using that medicinal marijuana oil had to be renegades in a sense to access the oil and then bring it back here. But when they had it, so there was a big mess up. So now growing medicinal marijuana is allowed indoors in Georgia. So there are medical marijuana grower licenses available. That is a completely different set of laws. But there is marijuana being grown in Georgia for that medicinal marijuana oil. It is only allowed to be grown indoors. And I say that because you don't have to worry about it cross-pollinating with hemp plants. And you don't have to worry about your hemp growing hot because of marijuana growing nearby. It has to be grown indoors. And now somebody could refute that. It might still be possible to cross-pollinate with another cannabis plant. I'm not sure. But I appreciate, I don't know if the lawmakers intended it, but I appreciate that there is some protection for the hemp growers by only allowing marijuana to be grown indoors in Georgia for now. I will also say that in the preamble to the Hemp Act, the lawmakers made it very clear that there is no plan to legalize marijuana. They put that in the preamble of the law. It feels like a slippery slope to me, but we shall see how those politics play out. This, for your reference, if you are planning to grow, if you are planning to get involved in the hemp program, I highly recommend you go ahead and take a screenshot of these 3 rules. The Georgia Hemp Farming Act, which is OCGA Section 223(1), the Hemp Grower Rules, which are the regulations that the Georgia Department of Agriculture wrote around hemp. They're in the rules and regulations, rules 40-32-2 and on. It might be 40-32-1 and then on. And then there is a USDA interim final rule that was referenced in the Georgia Hemp Farming Act that you may also want to familiarize yourself with. So now that hemp is legal, there is an open market in Georgia for hemp textiles, hemp seeds, hemp concrete, and more. There's this open gate now to figure out what can we use hemp for, a sustainable growing textile, what can we use it for, how can we use it? And Georgia wants to become a leader in doing so. Georgia wants to pioneer using hemp for different markets and for different purposes, and knowing how to grow it and what you could use it for. Georgia is on board for that. And I put it in little text, but I actually should have put it in really big text. Having a clear business plan before pursuing hemp is beyond advisable. It is a must, including doing market research, figuring out your cultivation and processing plan, and your security plans. You'll be growing hemp outdoors likely. You could be growing it indoors as well. I have the outdoor lens in this entire presentation. So you're growing hemp outdoors. Hemp is still cannabis, and it looks to folks who aren't sure the difference as though it's marijuana. So security plans are a really big deal. So having a clear business plan, I kind of went off on 2 tangents there, the business plan and the security plans, but those sorts of plans have to be made and in place with growing hemp. There are too many risks. There are too many variables. It's a new program. And I'll give you some insight from Lovey at Gilliam's Community Gardens. She's been growing hemp, and she gave me some phenomenal insight. It was shocking to me, surprising to me, some of the things she had to say, and we'll get to that in a little bit too. So tonight's focus is on growers cultivating hemp outdoors. You can grow hemp indoors. I don't really focus on that in this presentation. We could have a conversation in office hours about that if that's your plan. And I'm focusing on the growers more so than the processors or the permittees. And I went ahead and defined here that in the language of the hemp program, a licensee is a grower and a permittee is a processor. And we'll tease all of that out together. And I used some other acronyms. I may have already started using them. Apologies if it went whoop when I started it. The GDA is the Georgia Department of Agriculture. OCGA is the official code of Georgia annotated. The Georgia Comprehensive Rules and Regulations is just all of the regulations in the state of Georgia. And I'm going to reference the Georgia AG and the US AG, and those are the attorney generals. Those are the prosecuting bodies for Georgia and for the United States. All right. In Georgia, licensed growers to sell hemp and licensed processors to process hemp, they have a relationship from the get-go. The Hemp Act in Georgia only allows licensed growers to sell to licensed processors, period. You can only grow hemp if you are a licensed grower, if you're a licensee. You can only sell it to a licensed processor or the permittee. Likewise, licensed processors can only receive hemp from licensed growers. And licensed growers must have and maintain an agreement with a licensed processor to maintain the license validity. In fact, you may even need that relationship before you can fully apply for your licensing. And this is a lot of text, but this is another one to take a screenshot of for sure if you are interested in becoming licensed. Here are the requirements, the basic requirements for licensees in Georgia, for the growers. The first is an annual license fee of $50 per acre cultivated with a maximum license fee of $5,000. The applicant must be a qualified agricultural producer. And you must provide the Georgia Department of Agriculture with a legal description and the GPS coordinates to locate any hemp that you're growing, any hemp being cultivated in the field or in greenhouses or indoors. And according to the regulations, you also need to provide the Department of Ag with an aerial photo or a map with the boundaries of where you'll be growing your hemp. You must provide the Georgia Department of Agriculture with the name of the permittee with whom the applicant is contracting. So yeah, there you go. Even in the licensing information, you have to have the name of a permittee with whom you will be contracting to sell your hemp. You also provide the Georgia Department of Agriculture with written consent to allow the Department of Ag, the Georgia Bureau of Investigators, and other, and I put this in quotes because this is what is in the rules and regulations, and any other affected state and local law enforcement agencies to enter all hemp-related premises to inspect and ensure compliance. It is important to note here that giving that written consent is removing some of the constitutional rights that are involved with warrants and seizures and entering premises and looking through things and having access. You're giving written consent to allow the Department of Ag, GBI, and other affected state and local law enforcement agencies to enter all hemp-related premises to inspect and ensure compliance. You also must provide the Georgia Department of Ag with a criminal background check conducted by local law enforcement and in accordance with the regulations. Let's talk about each one of these things in a little bit more depth. Let's tease these things out now. For the proof of qualified agricultural producer piece, you may be able to use your current gate card, the agricultural tax exemption certificate card. There are select IRS forms that are mentioned in the regulations. I would assume that is a Schedule F. I don't know what other IRS forms may be helpful, but there could be others. And then the Commissioner of Agriculture, the Georgia Commissioner of Agriculture, still has the right to request tax returns, forms, sales receipts, or any other information or documentation to supplement and provide what they need to know about your qualified agricultural producer status. No license will be granted to any applicant that has been convicted of a misdemeanor involving the sale of or trafficking in a controlled substance, or an applicant who has been convicted of a felony, or an applicant who materially falsifies any information contained in the license application. I'm going to go back up to that first bullet. The applicant, no license is granted if the applicant has been convicted of a misdemeanor involving sale of. I bold that because it says nothing about possession of. And I'm glad to hear that. I have feelings that I could spend a lot of time on about them discluding folks with felonies. Yes, but I will put that to the side and just say I am glad that you can still apply for a license even if you have a misdemeanor involving the possession of a controlled substance. And marijuana is a Schedule I controlled substance under the Drug Enforcement Act, or Drug Enforcement Agency is DEA. It's a Schedule I drug. So yes, just keep in mind there are rules about backgrounds and records that come up for licensees. Here's where I caught a lot of misconceptions when the rules were being rolled out in the first place. I kept hearing these numbers of 25,000, 10,000, and 100,000 coming up in reference to being licensed. And that's for permittees. That's for processors. So if you desire to be a processor, which I would love to see possibly like a variation of a food hub, but a hemp hub formed in Georgia, where there is just a collective or a cooperative that's producing or processing hemp for the community in Georgia, that would be awesome. So these are the fees you'd be looking at for having something like that. A processor permit requires a $100,000 surety bond to be in place to be a processing facility. And the annual fee for processor permits is $25,000 for the first year, with an automatic renewal fee of $10,000 for subsequent years. So that is a hefty cost. Compare that to the $50 per acre of the licensee. The permittee fees for being licensed are a lot higher. They definitely are. But when you hear these numbers, it is a common misconception that these numbers apply to being a hemp grower. But remember, there is a licensee, that's the grower, that's $50 per acre is the licensing fee. It's an annual licensing fee of $50 per acre. And then the permittees, which are the processors, they have these higher fees of that first year of $25,000 and subsequent years of $10,000, and then having the surety bonds in place too. So here are some of the rules on that licensee and permittee agreement. The permittee and licensee must have a written agreement in place to govern the business relationship. Having worked with farmers and food businesses for over 4 years now, I will say there are many agreements and many things that happen that are not in writing. But this relationship, by statute in the state of Georgia, must be in writing. There must be a full written agreement. glad about that, not only because I'm a lawyer and I get paid to review those sorts of agreements, but also it sets expectations, and it's a piece of having that clear business plan and knowing what's going to happen if something goes wrong, knowing the market, knowing all of the T's to cross and the I's to dot. I'm glad to see that that's put in place for this still experimental hemp program in Georgia. So there must be a written agreement, and it must be provided to the Georgia Department of Agriculture within 10 days of execution. That is a hard deadline that is in the laws. Within 10 days of execution, you must provide the Georgia Department of Agriculture a copy of the agreement between licensees and permittees. And this includes the original agreement that's drafted and signed, and then any changes or amendments that take place that are also executed must be provided to the Georgia Department of Agriculture within 10 days of execution. There must be a transportation of hemp from licensee to permittee plan in conformance with the GDA's minimum standards in that agreement. So the agreement, in addition to other terms of how much people are being paid, when they're being paid, when the crop is coming, all the other terms that might be in that agreement, there also needs to be a term about the transportation of hemp from the licensee to the permittee, and it must be in conformance with the Georgia Department of Ag's minimum standards. And until December 31st of 2022, a permittee must reimburse the licensee for half the value of all of the input costs incurred with a destroyed crop. And that's in reference to a destroyed crop if you grow hot. If a crop grows hot and has to be destroyed, which it does if it grows hot, until December 31st, the permittee must reimburse the licensee for half of the value. So the person who is going to get this hemp and be able to turn it into a product and then sell it must help compensate the grower for all the work they did to get it to this point, for half the work that they did to get it this point, until December 31st. I strongly recommend that in the written agreement that is required by law, that a clause that matches this language be put in there even after December 31st. So the law requires the permittee to reimburse the licensee if a destroyed crop, but it's going to end December 31st. The law requires it, but December 31st of this year, the law will no longer require it. Put it in those agreements. Keep that kind of insurance, or I advocate for farmers. So I say make it even higher. Have permittees put their money where their mouth is of wanting that crop and wanting you as the grower to invest in that crop. Lovey also agrees that permittees and end users should be putting their money where their mouth is. And we'll talk more about having a CSA mindset with hemp when I talk about Lovey's tips and tricks and wisdom from the hemp growing program. And then, since the concentration of Delta-9 THC on a dry weight basis is the legal delineation of what is hemp versus what is marijuana, and what is legal in Georgia versus what is a Schedule I controlled substance, the Georgia Department of Agriculture has the right to enter the licensee's premises and randomly test hemp at any time. Okay, and they can do the same at the permittees. That's what the second bullet is. And this also means that you as a grower are going to want to test your hemp regularly as well. And there are very clear guidelines for the timing of testing your hemp before you harvest it. So when you start growing hemp, when you have your license, make sure part of your growing plan in the calendar year is marking those dates on your calendar of when you have to test your hemp for Delta-9 THC concentration before you can harvest it. I believe it's 15 days. I didn't write it down, so I can't guarantee that I'm remembering that correctly, but know those timelines. Actually, based on Lovey's wisdom, You should definitely have a test around 15 days because it sounds like she was testing every 4 days for sure, but then sometimes every other day, the Delta-9 THC concentration of her hemp. But just also know that the Georgia Department of Ag has the right to enter licensee and permittee premises to randomly test hemp samples. They have access to it. They can test it at any time. And there are regulations that govern the sampling requirements for growers and the lab testing requirements. The testing that must be done before harvest has to be done by a Georgia Department of Agriculture selected lab testing place. And they have selected one lab testing place. It is out in the rural areas, and you have to pay for them to come and test your product as well. So there is one lab that the Georgia Department of Ag recognizes. And from what Levy has said, they're pretty pricey. I did not touch on all of the regulatory requirements that are in the hemp program. There are still regulatory requirements for storage, for license renewal, for signage on licensed lots. There are laws that the regulations guide you to if you are selling seeds and live plants. Hint, hint, there is a market for that in Georgia. You still have to get your seeds and live plants from outside of Georgia, from what I understand. So if you're interested in getting into growing hemp to sell the seeds and the live plants in Georgia, you will also want to familiarize yourself with the Georgia seed law if you're growing seed, and the Entomology Act if you're growing the live plants. And there are also, the Entomology Act and the live plant regulations. If you're selling any live plants in Georgia, you want to be familiar with those live plant regulations too. So that includes if you're selling plants at a plant sale in the spring with tomatoes or collards or whatever else you might be growing at a plant sale. If you're selling live plants and you're not already familiar with the live plant regulations, the rules and regulations, rules 40-4-9, you'll want to familiarize yourself with. Anywho. And then there are regulatory requirements on record keeping and reporting. They require records, and they make it to where the Commissioner of Agriculture can ask you for any of those records, and you need to make them available, and you could have to write up a corrective action plan if they're not. So there is record keeping and reporting requirements that have to be up to par for the hemp program. So I'm going to pause there before I go into hot hemp. And I'm going to show you the online resources. I also see something just popped up in the chat. Are there different or any requirements for growers that want to grow hemp for the fiber? That is a great question. There is a lot of nuance in there. There's nothing else that I've come across in my research that you need in addition to the hemp program to grow it for the fiber. So for the growing it for the fiber, let me pull the slides back up. If you're growing just for fiber, I say just for fiber, but I don't mean that casually, because hemp is still a very precious plant and it takes a lot of work to grow it for that fiber. But if you're growing for fiber, this is your home base. These rules right here. If you are familiar with those, and I'll show you in just a second, that's where I'm pivoting next, is to show you where you find them, what they look like. If you have these printed off, highlighted, bookmarked, whatever you need, these are the rules and regulations that apply to the fiber. I don't know of anything else that does. If you're interested in growing for selling seeds and live plants, then add this to those bookmark laws, those printed out and put in a binder laws, those highlighted laws. But just, that's a great question. Just fiber, you're living in the hemp program world with the rules and regulations that apply. All right. So this is the House bill, and you'll notice this comes from legislation, legis.ga.gov. It's a much longer site if you want to screenshot that. But if you Google the hemp law or the hemp act, or if you find a link from articles that were written when it first came out, oftentimes you find a link to this bill right here. And I have used this to learn the hemp law in and out. I have used this version of what's available on the internet and has worked just fine for my needs. So this is the bill. It goes through everything. It tells you what the title is going to be. It tells you the intent. And I believe that's where they talk about never legalizing marijuana. And they have all the definitions, but this is still kind of, when it comes to statutes, the draft form, if you will. So if you want to look up the code and you want to see all of the changes that might happen to this code, a resource that I use for that, or for finding any statute, if it's OCGA, if it's the official code of Georgia annotated, I use this website very often to access laws, to access the most recent version of laws. If I just Google OCGA in a code section when I'm doing cursory research, this will usually be the first resource to come up. I have noticed some other resources coming up above this one lately, and I'm interested to check them out. If anybody else has any luck with any, always ping me and let me know you found something better. But when you click on a link to see a law on this Justia website, law.justia.com, it tells you up here in the top left corner that there is a newer version of this code section of Georgia's code. And if you click down, you see I'm in 2019 right now, and it's telling me there's a 2020 version. I always want to go to the most recent one. I don't think there have been any changes to this code section, but just in case, make sure you are on the most recent version of a law. And then this is the same thing we were just looking at that looked kind of like a rough draft version-ish. And this is put into the actual code format and cleaned up. So again, here are your definitions. You'll notice this section stops there, and there was a lot more in the last thing. This navigation bar up on the Justia website, I find it to be absolutely lovely. It tells you that we're in the Georgia Code. We're in the 2020 Georgia Code. We're in Title II, which is dealing with agriculture, Chapter 23, the hemp farming. We're in this specific code section, and that's what that double S means, is section 2-23-3. We're in the definition section. So if I click on the Chapter 23 hemp farming, here is a guide a clickable table of contents for all of the hemp farming statutes in this code section. So if I wanted to see the business agreements that I need in place, I could click on this code section and I could read through that. I don't always advocate for printing, but if you are someone who likes to have a paper copy, and I am, when it's something that's this crucial to getting business done, print each of these sections off and have your own version of the code available for you to scroll through, to highlight, to make notes in, so that you really know these things inside and out when you're applying for a hemp grower's license. Right, and I also want to point out this resource. This is fastcase.com. It doesn't require a subscription, but you can access laws, you can access the annotations, you can access if there have been any case law if there have been any cases that resulted in case law that affects a statute, you may be able to find it. So Fast Case is a more reasonably priced resource. And when I say more reasonably priced, I mean than like LexisNexis or Westlaw, which is what lawyers turn to get that common law information. I have a subscription to Lexis, so if you ever do need to look at case law, let's get together, let's do it during an office hour, and I have access to that resource for you as well. So that's some resources. And I have a sample license that I got from the Georgia Department of Agriculture, but I'm noticing that it's $7.54 and I still haven't talked about hot hemp. But this is a sample license that you can get off of the Department of Agriculture's website and go through it like the year before you plan to sell hemp or become licensed. Go ahead and familiarize yourself with everything that's on this application. If you have any questions, set up an office hour with me. Let's talk through it. If I can't provide an answer, I can take some time to help you find who can. Yeah, get those things cleared up so that you guys can start growing more hemp. Hot hemp. Hot hemp is any hemp that's grown and has a THC content higher than 0.3% by dry weight. So cannabis, the plant, creates THC as part of its natural life cycle. It is a part of the flower, and growers who are growing any sort of crop, you have plant growth, you have baby plant, you have flowers, and then you end up with seed pods, flowers, fruit, and the whole nine. So THC is created as you get into that flowering stage. It's a natural part of the cannabis plant's life cycle. The varieties of cannabis that are hemp are selected for their low THC levels to begin with. There are still factors, even when you are working in the land of hemp and you have a variety of cannabis that is hemp and that is supposed to have a low THC content, there are still factors that can cause the cannabis plant to sort of have a stress response, to have a stress response and to suddenly start spitting out more THC, producing more to try and get to the end of its life cycle. Think of this as when you plant collards and it becomes warmer than you expected, sooner than you expected, and that collard bolts immediately. It's not prime conditions for its living, so it's just going to try and get to flower. It's going to try and reproduce and to do what it was born to do. So the factors that can cause hemp to grow hot without even negligently growing it are the amount of light it has access to, the harvest time, how long it is allowed to grow, and then heat. And this is an important one because a lot of the seeds and a lot of the cultivars of the varieties that are called hemp, they come from places that may have a very different climate than Georgia. I specifically think about like Oregon or Washington State or Colorado. Not many of them have the hot summers that we have in Georgia. So heat is a huge factor in cannabis growing hot. If it's unchecked, if it's not managed, or even if you do all of those things, if it's too dang hot in Georgia, that plant can still grow hot. When you have hot hemp, which is a THC content higher than 0.3%, it is marijuana and it is technically illegal. But it's not going to automatically be treated like a Schedule I drug. So like deep breath, you can grow hemp, and if it grows hot, it is illegal at that threshold. But there's still this recognition that stuff happens and hemp grows hot sometimes. So there are special regulations, rules, and standards for what happens when. If Delta-9 THC concentration is higher than 0.33% on a dry weight basis, the entire crop is destroyed. If it's between 0.3 and 0.33, there will be a retest. And the violations, and there will be a retest, and then if it's still over 0.33%, it is destroyed. Violations are subject to enforcement solely in accordance with the Hemp Act. So even though you have marijuana on your hands, you don't have to worry about the laws that make marijuana illegal or possibly criminal coming down on you. Violations are subject to enforcement solely in accordance with the Hemp Act. And any negligent violations or other statutory violations may require a corrective action plan. And if the state law is violated with a culpable mental state greater than negligence, so if it smells of there being intent to grow marijuana instead of hemp, if there's any implications of that, then the Georgia Attorney General and the US Attorney General may be able to prosecute. And then I took direct language from the regulations because there is a statutory threshold for negligence in this case, which is great because negligence is usually a legally defined term defined by case law, and lawyers have a field day with it and it's a whole thing. But there's a statutory recognition of negligence, and it says licensees do not commit a negligent violation if they make reasonable efforts to grow hemp and the cannabis does not have a total delta-9 tetrahydrocannabinol concentration of more than 1% on a dry weight basis. So if you're still below 1% when you're growing, it's unlikely that you will be found to have a culpable mental state greater than negligence. You may not even have a negligent violation. It may just be a violation, and you may or may not need a corrective action plan. If you have a negligent violation, you're going to need a corrective action plan for sure. And then if it goes beyond negligence into a more culpable mental state, then you may not have that same wiggle room for even having an action plan. So the specific violations that warrant a corrective action plan are violations that the commissioner determines are negligent, or any failure to provide legal descriptions or global positioning coordinates sufficient for locating growing hemp. You must provide those very clearly to the Georgia Department of Ag. If anything changes, let them know immediately, because that could be a violation that then warrants a corrective action plan and more tail end work for you. A failure to obtain a license from the Georgia Department of Ag will result in a corrective action plan. And then producing cannabis sativa L with higher than the federally defined THC level for hemp. So basically any violation, you may have to be dealing with this. And the corrective action plans must have a reasonable date by which the licensee will correct the negligent violation. If you have a corrective action plan, you may be required to report to the commissioner on the compliance for up to 2 years after you put your corrective action plan in place. And if you have 3 negligent violations in a 5-year period, you may be completely ineligible for a license for 5 years after that 3rd violation. So corrective action plans sound like a pain to begin with, but having multiples could result in you being completely ineligible for the hemp program. Keep in mind, hot hemp is a Schedule I controlled substance under Georgia and federal law. Exclamation points. It must either be destroyed or a remediation plan under the regulations of Georgia must be put in place. You have something illegal on your hands when you have hot hemp. The state of Georgia is willing to work with you through the hemp program in terms of dealing with the fact that you have that illegal Schedule I controlled substance, but just keep in mind, hot hemp is that. The remediation plans, I wasn't clear on what those are. I'm not familiar. I haven't actually grown hemp, so I'm not sure what you could do to remediate hot hemp, but there was mention of that in the regulations. And then also bear in mind that all costs and fees associated with the destruction are the licensee's responsibility. Now, remember, I referenced until December 31st of this year, there may be some compensation from the permittee, but if you're getting licensed at this point and you're starting next year, all the costs and fees associated with destroying hot hemp are your licensee's responsibility unless you have an agreement otherwise with your permittee or with the end user. We have an example application here. Don't believe we have time to go over that. If you have any questions, I'm here. And then I'm going to go through this quickly, but I also want to go through this assertively because these are the words of wisdom from a current licensee. Thank you to Lovey Gilliam from Gilliam's Community Garden. She spoke with me about her experience with hemp. She was very passionate and shared mostly what she wished she knew before she got into it. And these are the three biggest takeaways I got from her. It's one, there are unexpectedly high costs associated with being a hemp program licensee. Two, hemp is a plant that needs constant care and attention. And three, she suggests entering the hemp program with a CSA mindset. I think that's rather important. And I'm going to talk through each one of these points a little bit more. I do recognize that it's 8:05. If you do need to leave, I totally understand. And I do hope that I see you on an office hour or a future webinar. But if you can hang with me, this is some good wisdom that Lovey shared. When she said unexpectedly high costs, I was shocked. I thought that $50 per acre was kind of the only fee involved besides having to actually grow it and tend to it and all of that. But she brought up the lab testing costs and that they shocked her. They shocked me too. For testing for analysis that you may give to a value-added producer or that you may want for your own use or for the permittee in general, she said ballpark around $1,500 every year for lab testing costs for content analysis and just for your own information as a grower. She said those can run $60 to $120 per test. And when she's growing hemp in a growing season, she tests every 4 days. And if the hemp is hot, she starts testing every other day, like as much as she possibly can to keep up with those THC concentrations. So ballpark around $1,500 a year for your own testing, just as a grower and wanting to know what you're growing. And then the required lab testing under the rules and regulations, because the sites are in rural areas and you have to pay for that person to come to your farm and to test all of your lots, the ballpark is anywhere from $1,500 to $5,000 a year to do the required lab testing under the rules and regulations. That number varies depending on how much you're growing and how many different varieties that you're growing. You have to test all of them. If you have 5 plots of hemp growing, you're going to have 5 lab tests for those required testings under the rules and regulations. And then the inputs for the proper growing conditions were just higher than she expected. The cultivars still come from outside the state of Georgia. I believe she mentioned North Carolina was where her baby plants came from, and they were delivered directly from the nursery. But some places you may pay a really high price and have to have them shipped, and there are definitely risks involved with that. So getting the actual product, it's coming from outside of Georgia, it can get pricey. And then she just made it clear that the soil must be right. You have to have every input down to a T with growing hemp. It's not like our friend okra that you can put in the Georgia red clay and it will still grow, which gets to the next one, that hemp is a precious plant, she said. And we talked for a while about the preciousness of her hemp plants. And in her words, she says, hemp is not like growing marijuana. Hemp is that baby, super careful, must take care of it and tend to it part before it becomes marijuana. It is a precious plant. Lovey checks her plants at dawn during dew time to see what's going on when the world is still dewy, when it's full sunlight during the daytime, and at dusk every day during a growing season of hemp. She said that she had issues with infestation of cabbage worms and the russet mite. And the cabbage worm, y'all are growers, I know you're familiar with that one, the little green worms that can take down an entire collard plant in a day, that become those adorable little moths when they are done with their life cycle. She said they blend in perfectly with the marijuana plant. It's so hard to catch the cabbage worms. And then the russet mite is the picture on the right. And that, from edrosenthal.com, that is a marijuana plant that the russet mites are on. And as you can see, that's like magnified in. It would be hard to spot those. She said it's impossible to see the russet mites until your plants have started curling to the point of being unusable. So she was very clear that it is hard to keep those pests off of marijuana as well, or excuse me, off of hemp. My bad. And the only instance Lovey knew of someone having to destroy a hot hemp crop was a farmer who planted it and just let it grow like any other crop. They treated it like everything else on the farm, where you put it in and you check it in a few days. That crop ended up growing hot, and that was the only instance that Lovey knew of someone having to destroy their crop. Now, granted, that's anecdotal evidence. There are only a handful of licensed sustainable farmers doing this, to my knowledge. But there was that differentiation of having to baby the plant and ending up with a good product versus expecting that plant to grow up a little bit and it growing hot, it growing up a lot of it. And her last nugget of wisdom was to enter hemp growing with a CSA mindset. And I'm so glad that she shared this wisdom. I think this is a great takeaway from someone who's been in it and who has been able to see where the actual bottom line is affected with growing hemp. Hemp is still experimental in Georgia, and in Lovey's words, it's an expensive experiment. Value-added producers are still getting used to how to make products, what varieties are best for making products. Growers are still getting used to growing hemp in these hot, humid conditions with the pests that we have. And it's a lot of assets in the front end and hoping that it's going to work out in the back end. And right now, without agreements that do anything otherwise, the financial burden is on the grower to figure those things out, to make sure that they have an end buyer. So Lovey offers the mindset of community supported agriculture. If makers and buyers want to try different strands or qualities, they should support the growers financially in the experimental phase. So this is another place that well-drafted agreements come into play. Just as you would have a well-drafted community supported agriculture agreement to allow consumers to pay upfront for a farmer to have a growing season, and they get to benefit from what does come from that. Same thing in this hemp scenario. Have producers or value-added producers, have them enter into agreements with you that will give you money on the front end, and the loss is shared between the two of you, rather than the loss being something that the grower takes on, solely the growers in the end. And the last bullet is kind of in the CSA of growing mindset, but also in just this cooperative, sustainable growing in the state of Georgia in general. This is a great place, as this is a pilot program or an experimental program, not a pilot program, it's happening. But as Georgia is learning, as Georgia growers are learning, this is a great time to lean on community for best practices with growing, lean on community. And this is a place where there are still ears that are listening to advocate for where things are not working for everyone in this. It's still a new program. There could be changes, there could be alterations, so that small scale sustainable family farms really can grow hemp, make textiles, make novel products, find new markets, and make a living doing it. This is a very new, exciting opportunity for sustainable growers. And as a lawyer, I'm here to help with that advocacy too. If the community of sustainable farming is realizing this doesn't work for us because of X, Y, or Z, let's start figuring out what that X, Y, or Z is. Let's start putting a voice to that and telling the lawmakers how to make it better for sustainable farmers. I believe this is a space where there's a lot of optimistic room for making this program work for sustainable, small scale family farms. So the key takeaways, thank you for being patient during my soapbox moment, are that hemp in Georgia is cannabis sativa L with a THC concentration of less than 0.3% on a dry weight basis. Anyone growing hemp legally in Georgia must be a valid licensee and follow all rules and regulations and have a plan. Growing hemp is a tedious process, and cannabis with THC concentrations higher than 0.3% result in destruction of an entire crop. So have a plan in place. Make that money, make your business as sustainable as you're growing. And keep in mind that a lawyer fits in here with business planning, helping you with rules and regulations and navigating them, agreements with your processors or the permittees, corrective action plans, agreements with potential buyers and value-added producers. And think of the law firm as part of your team and all of these moving parts, not just who to call when stuff hits the fan. And if you have more questions, sign up for office hours, calendly.com/thelawfarm/office hours, or email me at michelle@thelawfarm.com. Do y'all have any questions, comments, thoughts, experiences, or anything else you'd like to share before we leave tonight?
Thank you very much. This is Lizzo Jones. It was very informative, and you gave me a lot of insight that I had no idea was surrounding actually performing processing. So thank you very much for having this webinar. Very knowledgeable and gave me a lot of great insight.
It's absolutely my pleasure. I'm glad you were here tonight. And please, yeah, don't forget, I am here if you have follow-up questions, for sure. It's my pleasure. All right, thank you all so much for coming out this evening. This does not need to be the last time you see me. I hope I see you at a workshop, webinar, or an office hour soon. Thank you, thank you. And have a great night and stay cool. It's hot out there.
Thank you.